Students, I welcome you all to lecture number 1 of Family Law. Okay, this is a part of Clat lecture series sponsored by Sri Jendra Rank Zone, and I am your mentor Shekhar Gehlot. Okay, so family law, when we are talking about family law, family has been in existence from time immemorial. Okay, family is a unit. So, what is a family? I can only say family is a unit of people. A unit of what people? People which are related to each other by birth. Okay, they are related to each other by birth or by marriage, and it stays together. Usually it stays together, follows similar practices and traditions. They follow all the practices and traditions which are similar. Okay, the concept of family, there is nothing new in family. Okay, family has been there since time immemorial. Okay, that means we cannot even remember from the first time when a family came into being. Okay, or from when we are seeing the tradition of family. So that means the family law is a traditional law, or it's going to be a law which is very old law. Okay, because we are having family from such a long time. Okay, such a long time, that means family law is largely a traditional law. Traditional Hindu law. And now, what is traditional law? Let us see. Traditional Hindu law is based on guidelines and concepts elucidated in the Vedas, because Hindu law we were guided by Vedas. Okay, so initially our law came out from Vedas. That is why we call it a traditional law, because first source of law was Veda. First time we got law was from Vedas. These guidelines evolved into rules laid down by sages. Now, sages, saints, okay, they read these Vedas and then they told all people what the Vedas say, okay, and they got evolved into rules. You have to be good, you have to be moral, you have to be ethical, you have to do this, you have to do that, okay. Sages told people, people followed sages, and then these rules were enforced by the rulers. Okay, kingdoms, they enforce the rules, okay, told by the sages to the rulers or to the people. Then that is how they become crystallized in our behavior. Okay, when it got enforced by the rulers, people started behaving in such a manner, and it became the de facto law of the land in ancient India. Okay, it was the law of the land in ancient India. What was the law of the land? Vedas were the law of the land in the ancient India. The aim of these laws is to establish dharma and through it attain moksha and salvation. This is the traditional concept of the law. Okay, traditional purpose of the law, or say Hindu society, was based on notion that each has to follow his dharma and ultimately must attain moksha, or say nirvana, or say heaven. It is something like this, as we have seen in our traditional epic serials, etc. Okay, so what is dharma? Nobody knows dharma. Okay, no one can define dharma. Okay, it's an abstract term. One can simply say doing what is right is dharma. Now, what is right? They say which is just. Now, what is just? Which is fair? What is fair? which is based upon truth. What is truth? What is truth? Okay. Now see, this is how philosophy of law, philosophy of traditional Hindu law keeps on evolving. Okay, now what is truth? Somebody will tell about truth, that is truth. Then somebody will come and ask you what is truth. Okay, being this and that. So this is ever evolving concept. Okay, that is why I call law is a ever evolving concept, because there we cannot define law. Can we define dharma? We cannot define dharma. There are always new. There are always going to be new definitions for the time. What is dharma and what is right at particular point of time? What is just? What is fair? What is truth? Okay, it all depends upon circumstances and the society we live in. Okay, so we can never have something which is, we can never have a law which is uniform. Law can never be uniform. Okay, and it keeps on evolving. Similar is the case with our family laws. Okay, family laws. Either Hindu, Muslim, Christian, okay, or any other religion. These all religion began with some laws. Okay, then people started finding some faults in those laws. Then when the faults were found, then some new solutions came up. Then those new solutions became the law. Later on, society changed, those solutions became the problem. Then new solutions were found, then those solutions became law. This is how law keeps on evolving and keeps on changing. Like we have a Farmers Act, okay, which is now supposed to be the new solution for some problem of the middleman and the misery of farmers. Okay, so this is all about law, and this is all about family law, how our family law evolves. Okay, in modern times, the same law have been retrofitted to suit present conditions and have been codified in the form of several acts such as. Now, retrofitted means we are trying to fit laws, traditional laws in the modern time. Okay, we are trying to fix traditional laws in the modern times so as to preserve what? We are trying to preserve the traditional values of Hindu society. Okay, we are trying to preserve the traditional values of the Hindu society. Now, these are some laws which we are going to read when we talk about family law. Hindu Marriage Act, we are going to read. Hindu Adoption and Maintenance Act, Hindu Minority and Guardianship Act. Now, first of all, let us see sources of law. Sources of law means, source means origin. Okay, origin of law, where law began, or how do we get our law? How do we get our law, or how we got our law? Okay, this is the answer for that. We got our law. First is from Shruti. Shruti. First is from Shruti. Shruti is a Sanskrit word which means what is heard. Okay, what is heard? Shruti is what is heard. So, what is heard means these books are considered to be very words of the deity. Both the language and the rules contained therein are considered divine. What is heard means some sages. Okay, Okay, it is believed that some ancient sages belonging to Hindu tradition, they had a discussion with their own divine God, and they had a discussion about what is truth, what is dharma, what is this and that. Okay, all the issues which a society may come across, and the divine gave the answer as per his feelings or beliefs. Then they wrote them down and they become the law. What are Shrutis? We have heard that we have four Vedas: Rig Veda, Samved, Yajurved, Atharvaved. Then there are six Vedangas. Okay, appendages to Vedas, something which is left to be written in Veda. Then someone wrote it later and appended it to Vedas. 18 Upanishad, we have 18 Upanishads, or they are called Vedantas, which are concluding portion of Vedas. If something is still left to be written, then we find it in the Upanishads. There were around 1180 Upanishads originally. Okay, originally there were these many Upanishads, but somehow they were compiled and now we have only 18 Upanishads. So these are Shrutis, 4 Vedas, 6 Vedangas, and Upanishads. These are considered to be the language of the God, straight what God said. Okay, it is contained in Shruti. So from Shruti, that is how we got our first law. First law of first Hindu law we got from Shruti. Then came Smriti. Later on it is Smriti. Smriti is again a Sanskrit word which means which was remembered. Okay, which was remembered. It is considered to be the words of deity expounded by sages. The rules are divine, but the language is of human origin. Manusmriti, Dharmshastras, Bodhayan, Dharmshastras, Dharmsutras, Yajanvalkya Smriti, etc. That means now sometimes sages may not have been able to write down just in front of the God. Okay, so God told them and they later on wrote it down. So whatever they remembered, okay, whatever they remembered, they wrote it down, and that is called Smriti. Okay, this is our second source of law. Then comes Nibandhans. Nibandhans, which is digest or commentaries. Commentary means someone is providing comments. Someone is providing comments. Now, someone will provide comment on what? Either on Smriti or Shruti. Some later scholars they read Smriti and Shruti and they detailed or explained and provided their own comments on the translation of Smriti or Shruti. That is called Nibandhans. The Smritis did not agree with one another in all respects. Okay, so these Smritis did not agree. All these Smriti, there are so many others. They did not agree with one another in all respects, and this conflict led to several interpretations or Nibandhas. Okay, there was a conflict, so people started resolving the conflict, and that is how we got another source of law, which is Nibandhas, by various commentators. The commentators did not merely interpret the Smriti, but they also recounted the prevalent custom and usages. These texts gathered the scattered material available in the preceding text and presented a unified view for the benefit of the society. Thus, digests very logical and to the point of their approach. Okay, thus digests are considered, these nibandhas are considered to be very logical and to the point of their approach. Why they are considered logical? Because they carried out a research. When we carry out a research, we definitely come to a conclusion, isn't it? And conclusion is obviously logical if the research is good. So they carried out a good research on smritis and shrutis, and then they came up with their own conclusions, and they tried to resolve these conflicting views between the various shrutis or smritis. That is called nibandhans, and that is why we call them very logical. Various digests have been composed from 700 to 1700 BCE, okay, before the birth of Christ. The most popular are or Vijneshwara's commentary. Vijneshwara commentary is most popular. Mitakshara or Yajnavalkya Smriti is the most important legal treatise followed almost everywhere in India except in West Bengal and Orissa. It was compiled in 11th century. So see how old this Hindu law is. It was compiled in the 11th century. That means thousandth year. Okay, now we are in 2000 year, so almost more than 1,000 year old, and this Mitakshara law is still a valid law. This Mitakshara is still a valid Hindu law in most part of the country except West Bengal and Orissa. Okay, so throughout the country, this Mitakshara school of thought, which is based upon Vijneshwara's commentary, is followed. The Daya Bhaga, prepared by Jimutvahana. Now there was another commentary that is called Daya Bhaga. It was prepared by Jimutvahana in 12th century. It holds supreme authority in Bengal. Okay, people in Bengal and Orissa, they See, Bengal and Orissa used to be one. At one point of time, it used to be one state. Okay, so that when it is an authority in Bengal, that means it's an authority in West Bengal and Orissa as well. Mitaksha and Dayabhaga are still the legal basis of Hindu law on areas where there are no legal enactment. So when there is no legal enactment, okay, now law gives something and there is no legal enactment. That what is done? Suppose there is a section in Tamil Nadu, they perform marriage by placing vermilion on the forehead of girl. Okay, or by giving her Bangal Sutra. Bangal Sutra is a necklace, okay, necklace which a married lady is supposed to wear. Okay, I don't know what is it referred in Tamil Nadu. Bangal Sutra is Sanskrit word. So now law does not speak anything about putting vermilion sindoor to a girl or Mangal Sutra. Okay, so now law is silent whether this could be done or not. Then what we will do? We will find it in the Mitakshara school. Why? Because Tamil Nadu follows Mitakshara school. Then we'll find it in the Mitakshara school. Whether in Mitakshara school of thought. What is Mitakshara school of thought? Vijneshwar's commentary. Whether Vijneshwar's commentary talks about Mangal Sutra or vermilion or not. If it does, then we'll see how it deals with it. Okay, that is how these laws are applicable. Custom and usages. Okay, custom is and usages. What are custom and usages? Usage means something which is followed daily. Okay, that is also called custom. Custom is a habitual course of conduct generally observed in a community. It is a set of rule of practices which, as a result of very long usage, has obtained the force of law in a particular community or in a particular area. In Hindu law, customs modifies and supplements the written law. In Hindu law, we follow customs, okay, and they complement the written law. I'll give you an example. Jallikattu. It has been a custom and we have been following it from time immemorial. Okay, in Tamil Nadu or southern states. So now it is a valid practice. Okay, or the practice followed at different temples. The practice followed at different temples. That is also a custom. Like in Tamil Nadu, there are some temples like Meenakshi temple, Madurai temple, other temples are there, where if you wish to visit those temples, then you have to wear a specific attire. That specific attire is you have to be bare chest, you have to wear a dhoti, and then you have to put a janev. Then only you can visit. Okay. Or in Tamil Nadu, people are putting different kind of tilak on their forehead, while in North India they are putting a different kind of tilak on their forehead. Okay, that is called a custom. Okay, or tradition. Okay, custom is habitual course of conduct generally observed in a community. So southern community is following a different, western community different, eastern, northern, all are they following their own different customs. Okay, and some customs are which are followed by Hindus all over India or all over the world, like Deepavali. Okay, Deepavali. These celebrations, these festivals, Raksha Bandhan. Okay, they all are nothing but they are customs like Hindu calendar year, Hindu financial year. Okay, if you go to USA, their financial year is the calendar year. Like the financial year will begin in 1st of January and end in 31st of December. But our financial year begins in 1st of April, ends in 31st of March. That is the Hindu calendar. That is the custom. Okay, that is the custom. So custom is a habitual course of conduct which we have generally followed. Okay, and it differs on place to place. Okay, it differs in food items as well. Okay, different cuisines are there. Southern food is different, northern food is different, Mughlai food is different, Chinese is different, continental is different, European is different. Okay, all foods are different. So these are customs and usages. So they also become law. Okay, they also become a kind of law. Like Hindu calendar, it's a law now. We follow Hindu financial year. Jallikattu is a kind of law. Okay, similarly, Deepavali, it's a kind of law everyone has to celebrate, isn't it? Then we go to Puranas. The Puranas, 18 in number, are codes that illustrate law by instances of application. However, these texts are not considered authoritative and are overridden by Smritis. So Puranas try to explain the law. They give examples. Situation A, this should be done. Situation B, that should be done. If you have a similar situation which finds a mention in the Purana, then you can follow the rule given in the Purana. But usually their authority is limited. Why? Because Smritis override them. Now, these were the ancient sources of law, ancient sources of Hindu law. Now, what are the modern sources of Hindu law? Modern means prevalent times, okay, recent sources. First one is legislation. What is legislation? Law made by the parliament. Okay, law made by the parliament or state legislature. Parliament is for the union, for the India as a whole. State legislature is state specific. So state of Gujarat will make law for people living in state of Gujarat. State of Tamil Nadu will make law for people living in state of Tamil Nadu. Okay, so state legislature will make law for the state people. Union legislature, that is parliament, will make law for the whole of the India. So the modern source of law of Hindu law is legislation. Okay. Acts of Parliament which replaced customary Hindu laws such as Dayabhaga and Mitakshara in vogue before independence. In vogue means in fashion. These laws, Dayabhaga and Mitakshara, they were in fashion before independence, but we now have adopted our own Act of Parliament, laws of Parliament, but these laws are based upon Dayabhaga and Mitakshara only. Okay, we are only trying to clarify them. The legislations modify and supplement ancient texts in certain respect. The most important statutes are the Hindu Marriage Act, the Hindu Adoption and Maintenance Act, the Hindu Succession Act, and the Hindu Minority and Guardianship Act. These are the most relevant laws applicable to Hindus. Okay. Then we have another source of law, modern source. Where do we get our law from? First is legislation. Then we get our law nowadays from precedent. Precedent is a judgment delivered by a court. Okay, so judgment becomes a law and we have to follow it. We are compelled to follow it. Okay, judicial decisions to certain extent have become a source of Hindu law. Decisions of the Privy Council is the highest court of land when India was a slave, sorry, not slave, I'll say colony to Britishers. Okay, then our highest court of law was Privy Council, which was in United Kingdom, London, and the High Courts. Now it is Supreme Court and High Court are binding on subordinate courts. Earlier it was Privy Council and High Court. Now it is Supreme Court and High Court. The doctrine of stare decisis started in India from British rule. Okay, because we were British colony. All cases are now recorded and new cases are decided based on the existing case laws. So we keep on recording cases. It is just like Puranas. We keep on recording cases. Now we have recorded, suppose a judgment is there on situation A. Okay, now court has given a judgment on situation A. We keep a record of it. Now tomorrow similar situations come, like situation A. So we'll now not waste a lot of judicial energy on going into those things again. We'll just simply say whatever was done in situation A, you do it. Whatever was done in situation B, if your situation is similar to situation B, you do that. Okay, that is how we get precedent. All cases are now recorded and new cases are decided based on existing case laws. Today, the judgment of SC Supreme Court is binding on all courts across India, and the judgment of High Court is binding on all courts in that state. Okay, and who are administering the justice, who are protecting the law? Definitely the courts. So when courts are bound by each other, that means they are following precedent. If one court is saying something about situation A, other court should also follow similar in the case of situation A. So that is how we become uniform in our judgments. Okay, uniform in our judgments. Justice, equity, and good conscience. This is another source of law. Justice, equity, and good conscience. It says, now it says, sometimes or many times a situation may arise where there is no law. Then how do you decide in those cases? It says in those cases the judge will decide upon his own sense. His own sense means criminal community's sense of justice. What is just? What should be just in this case? Equitable? What should be fair? And what should be done? Okay. In a situation where no rule is given, the consensus is that a sense of reasonableness must prevail. Something you do something reasonable. Okay, which is in benefit of all. That is called justice, equity, and good conscience. Equity means fairness in dealing. According to Gautama, in such situation, the decision should be given that is acceptable to at least 10 people who are knowledgeable in Shastras. This is a traditional way. Okay, that if 10 people believe that this should be done, then we should do it. Yagyavalkya has said that wherever there are conflicting rules, the decision must be based on Nyaya. Nyaya means true justice has to be there. This has been adopted in modern times as well. Okay, this is justice, equity, and good conscience. Okay, so when there is no rule, then how should judge deal with the law? That means judge will apply the social standards. Okay, and judge will come to a situation where a reasonable order will be passed. Custom, like we have discussed custom. Okay, custom is the we discussed custom as a ancient source of law, but custom is also a modern source of law. Even today, customs are relevant, and whatever we follow nowadays, whatever is the practice, okay, or a tradition, with particular area, then we follow it. Okay. So we follow custom even in the modern times. Custom is a habitual course of conduct generally observed in a community. Like let's take the case of Sabrimala. Sabrimala temple had its own practice that no menstruating women should enter the temple. Okay, only male are allowed, or women below 10 or above 55 are allowed. Okay, this had been the custom of the temple. This is the rule which we were following since time immemorial. We cannot even remember when we started following that custom. Okay, it is as old that we don't even know when this started. So, but Supreme Court thinks some other thing, but that decision is right now under review. Okay, most of the Hindu law is based on customs and practices followed by the people across the country. Even Smritis hold customs as transcendent law and have advised the kings to give decisions based on the customs after due religious consideration. Even the Smritis say that even a king, when he is deciding, now we can replace king with a judge or the government today, that they should give due consideration to the custom. There are four kinds of customs. Family custom prevalent to particular families, okay, which are prevailing into particular family. We have our family customs, isn't it? We have to touch the feet of our elder, okay, or eldest son will become the karta, okay, something like this. Or after marriage, the girl will go to groom's house. These are the customs of the family. Okay, these are the customs of the family. Okay, how do we perform our marriages? Okay, these are customs of the family. We have a class or caste custom prevalent in particular caste or class and binding on members of that caste. Now we have a family custom, then we have a custom as per the class or as per the caste. Like Brahmin would say, we will wear a sacred thread. Okay, like Brahmin will wear a sacred thread around. Somewhere, animal bali, a temple is given by caste or community. Okay, animal bali or sacrifice, something like this. Okay, it's 12 o'clock. So community has their own customs as well. Okay, we have village deities. India belongs to villages. We all belong to village somehow, and all village have their own gods. Okay, we have our gods, but we have our god in the villages as well. Gods of villages, that is the custom. Local or territorial custom. Okay, local or territorial customs, such as customs which are prevailing in Haryana or northern India, okay, or southern India, like custom maybe like practice of food habits, okay, food habits. They are territorial. Whole Tamil Nadu or whole southern range is having similar food. Western range is having a different food habit. Okay, and the clothing. Okay, clothing, different kind of clothing everywhere. Language. Okay, they are all territorial customs. Guild custom or custom followed by traders. Guild means customs. Guild are trade associations. Okay, custom followed by traders. What are the custom followed by traders? We discussed financial year. India's financial year is based upon the financial year followed by Guild Traders Association. Whatever financial year they started following, now they are following it like these. Okay, we have different kind of customs. So custom is also a source of law. It was a source of law in the ancient time, and it's a source of law even in the present times. Essential attributes of a valid custom. If we want to establish a custom or a usage as a custom, that this custom is a valid custom. Okay, if we want to prove some usage to be a custom and to be just like a law, then what are the necessary ingredients of a custom, of a valid custom? Ancient, it has to be very old. If something is new, that means it's not a usage. Something new cannot be called a usage, isn't it? A usage will become a usage only if it has been performed over and over, and over for hundreds of years. Then it becomes a part of our habit. Then only it can become a custom. First is ancient. Customs should have been in existence for a long period of time and cannot come in existence though through an agreement. Okay, it does not come into existence through an agreement. Okay, people habitually follow it. There is no agreement. People follow it out of habit. People are habitually following it. Okay, that is a usage. Though there is no definition of ancientness, 40 years is deemed to be ancient enough. 40 years old is deemed to be ancient enough. Though there is no definition of how old, 100 years old, 200 or 500, whatever. Okay, but we assume that something which is 40, 50 years old is good enough to be called a custom. Continuous custom must have been continued or been observed without interruption. Once abandoned, it cannot be revived, like the custom of sati. Now people have abandoned sati practice. Now we cannot revive it. Now we cannot say we'll start following sati or child marriage for that matter. Now we have given up child marriage. We cannot revive it. Okay. Reasonability. Custom should be reasonable and fair. What constitutes reasonable and fairness varies over time to time. Now, what is reasonable, like we discussed? Reasonable keeps on changing as per the situation. Once upon a time, sati was reasonable, but now we do not consider it reasonable anymore. Once upon a time, even child marriages were reasonable, but today they are not reasonable. Okay, so it keeps on changing with the time. Devdasi system. Devdasi system is a system where young girls are prostituted. Okay, it was a valid system. It was a valid custom followed in West Bengal and other areas. But now it is unreasonable. We cannot allow a young girl to be put into prostitution in the name of some custom. Okay, that is highly unreasonable. We have to save the young child. So now it is unreasonable and unfair now. But was an accepted norm not too long ago. Not too long ago means we have a decision which criminalized Devdasi practice only in year 2010 or 9. Okay, till 2009 or 10, Devdasi system was in existence. Certainty. Custom has to be clear. Custom has to be certain. Custom cannot be vague. Okay, custom cannot be such that people do not know what is a custom. Everyone is doing whatever they feel like. Then it cannot be called custom. Custom must be definite and clear cut in respect of its nature, the locality, and people whom it affects. Any vagueness that creates confusion will render the custom invalid. Then it has to have uniformity. Custom should be uniform and obligatory on all members of the community. Okay, custom should be uniform, followed by all, and they should be obligatory, mandatory. People are mandatorily following it. Okay, moral. Custom must not be immoral. We cannot have a custom which is immoral, okay, because customs are based upon the practices of the society. And when a society is practicing something, then definitely society will not practice something immoral, okay, or opposed to public policy. This again is relative term. Okay, yes, morality keeps on changing with the time. Like we had a Varna system once upon a time. Okay, Varna system. Varna system is caste based job or skill. Caste based job or skill, but now we are not following it anymore. At time it used to be moral, but now it is highly immoral. So moral keeps on changing. A custom to marry one's granddaughter has been held invalid. Okay, this custom was followed somewhere in Tamil Nadu and particularly in Tirunelveli. Okay, this custom, it was a custom in Tirunelveli to marry one's granddaughter, but now granddaughter from daughter. granddaughter from daughter, but now it has been held to be invalid. A custom that dissolves the marriage and permits a wife to remarry upon abandonment and desertion of husband was held to be not immoral. And in another case, a custom which allows a woman to divorce her wife and remarry was held not to be immoral. Okay, so this is how things go on. Conformity with the statute. Custom cannot derogate from a statute unless the statute saves any such custom or generally makes exception in favor of rules of custom. It says statute means a law made by the parliament or state legislature. If law has been made, then the custom cannot exist. Okay. If law is made and law says something against the custom, then we are bound by the law. Okay, we are bound by the law. We have to follow the law. If law goes against the custom, then law will take over. But if law leaves some space for the custom, then law will operate as well as custom. Both will operate simultaneously. Now let us see who is a Hindu. We are talking about Hindu law, but we should know what is Hindu. Okay, what is Hindu? We should know. Section 2 of Hindu Marriage Act defines who is Hindu. Okay, Section 2 defines who is Hindu. A person who is Hindu, Jain, Buddha or Sikh by religion. Okay, a person who is Hindu, Jain, Buddha or Sikh by religion. Converts and reconverts. Those who have converted to Hinduism. Okay, those who have converted to Hinduism. Suppose someone is Muslim, he has now become Hindu, he will be a Hindu. A Christian has become a Hindu, he will become a Hindu. Or a Hindu had become a Christian, but now he has reconverted to Hinduism, he will become Hindu. Okay, a non-Hindu will become a Hindu by expressing a bona fide intention to become Hindu, accompanied by conduct of conversion by undergoing a formal ceremony of conversion or reconversion prescribed by the caste or community to which he or she converts or reconverts. Okay, so conversion, you can become Hindu or you can become any other religion person. Hindu by birth, okay, someone who is Hindu by religion, the one who follows these religion, Hindu, Jain, Buddha, Sikh, he is Hindu by religion. Someone who has become Hindu by converting to Hinduism. Someone is Hindu by birth. Okay, a person who is born to Hindu parents. Two people are Hindu. A child is born. The child is Hindu. Okay. A person can be Hindu if she has been raised as a Hindu. If only one parent is Hindu. Suppose one parent is husband is Muslim, wife is Hindu. Then what would be the religion of the child? Usually Muslim. But if the child is brought up like a Hindu, if the child is brought up like a Hindu, the child shall be Hindu. If the child is brought up like Muslim, he shall be Muslim. This is the case where one parent is Hindu and one parent is some other. Then in that case, if the child is brought up like a Hindu, he is following Hindu tradition, Hindu celebrations, Hindu festivals, then he shall be Hindu. Person who are not Muslim, Christian, Jew or Parsi by religion. Now any person or every person who does not call himself Muslim or Christian or Jew or Parsi, they all shall be Hindu. Okay, they all shall be Hindu. And persons who are not governed by any other religious law will be governed by Hindu law. So that means Hindu law is very wide. Hindu, Jain, Buddha, Sikh, all Hindu, conversion Hindu, by birth Hindu. If you are raised as, if you are grown up as Hindu, you are Hindu. If you are not Muslim, Jain, Jew, Parsi, you are Hindu. If you are religionless, you are Hindu. Okay, if you are religionless, you are Hindu. So Hindu is a very broad term. Hindu Marriage Act, HMA, whenever we write the word HMA, we are referring to Hindu Marriage Act. Now to whom this Hindu Marriage Act does not apply to? Okay, so Hindu Marriage Act applies to Hindu. And let us see to whom Hindu Marriage Act does not apply to. Those who have renounced Hindu religion. Those who were Hindu, renounced means giving up. Those who have given up Hindu religion, they do not follow Hindu religion anymore. Hindu Marriage Act is not applicable to those people. Person descended from Hindu ancestors and on account of marriage and converted into new community. Person who were Hindu by birth, but now they have married to some other religion person and have converted to the new community. Okay, then they shall not be Hindu. Children whose either parent though is Hindu are not brought up as Hindus. Children whose one parent is Hindu but they are not brought up as Hindu, they are brought up as the some other religion of other spouse, other parent, then they will not be Hindu. If one or both parents convert to another religion, child will continue to Hindu unless child is also expressly converted. If both parents they convert to Christianity or they convert to some other religion, Islam religion, but the child is not converted, then child will continue to be Hindu. Okay, but if the child is converted, then child also will cease to be a Hindu. And who is a Hindu? The HMA Act does not allow to someone who is not a Hindu. Scheduled tribes, unless the government includes them by notification. Okay, if government brings a notification that these scheduled tribes they shall be governed by Hindu Marriage Act, then they shall be considered Hindu. But if there is no such notification, then they will be governed by their own traditional customs. Whatever custom they follow, they will be governed by those customs. Maneka Gandhi versus Indira Gandhi. In this case, there was a contention. Okay, that because Indira Gandhi she was married to a person who was Parsi. Okay, some people say that he was a Muslim, some people say he was a Parsi. So Maneka Gandhi filed a case that Sanjay Gandhi cannot be a Hindu. Okay, so it was held by the court that Sanjay Gandhi was Hindu because though mother was Hindu and father was not Hindu, but he was openly brought up as Hindu because Sanjay Gandhi was brought up as Hindu, so he was Hindu. Perumali versus Punuswamy. Supreme Court holds a person can be a Hindu if after expressing the intention to become a Hindu, follows the custom of caste, tribe or community and the community accepts him. If someone wants to be Hindu and he says I want to be Hindu and the Hindu community accepts him into his fold, then he will be a Hindu. Sapna versus State of Kerala. The son of a Hindu father and Christian mother was held to be Christian. Why? Because this person was raised as a Christian. Okay, this person was raised as a Christian, though the father was Hindu. And traditionally, whatever is the religion or whatever is the practice of the father will become the practice of children as well. But here in this case, because this person was brought up as Christian, because there was a discord and child was living with the mother was living separately from the father. So she brought the child as a Christian. So court said though the father was Hindu, but because the child has been brought up like Christian, so he is a Christian. Shastri versus Muldas. Supreme Court held various subsections of Hindus such as Swaminarayan, that is in south, Satsangis, it's in north, Arya Samajis, they are spread everywhere, are also Hindus by religion because they follow the same basic concept of Hindu philosophy. Okay, so these people are also Hindu. They are following their own sections though, they have their own practices, but largely their practices are which are followed by Hindu religion as well. So they are also Hindus. Now we'll discuss the essentials conditions of Hindu marriage. What are the essentials conditions of Hindu marriage? Now we have discussed what is Hindu. Now, how can a Hindu marry? Marriage in traditional Hindu law is regarded as a permanent and eternal union. Okay, in traditional Hindu law, marriage is regarded as permanent and eternal union. That it's permanent, it cannot be broken up, and it's eternal. Eternal means will last for 7 births, 7 lives, isn't it? We say that marriage is for 7 lives or 7 births, isn't it? That is the traditional Hindu concept. That is why the concept of divorce was originally not there in Hindu law. There was no concept of divorce in the Hindu law. Okay. because marriage was considered to be a permanent and eternal union. Once you get married, you can be separated by death only. This was the philosophy, and that is why it was very difficult to think of divorce some 30 40 years ago. Now it is a different picture. But 30 40 years ago, taking a divorce was very difficult for Hindus because our belief is that Hindu marriage is for forever. Before the enactment of Hindu Marriage Act 1955, Hindu marriages were governed by Dharma Shastras and customs. Okay, Dharma Shastras and customs because Marriage Act came in 1955 and there was no law for marriage. So every community was having their own laws for the marriage. Okay, but now law is trying to provide some essential ceremonies. Law is now trying to lay down that at least you do these four things, these three things if you want to call a marriage a marriage. You do these three things. Now, what are those three things? Let us see. Sorry, more than three things. These are the conditions right now. Then we'll go to the ceremonies. These are the essential conditions for a valid marriage. Hindu. Okay, first of all, both parties to the marriage should be Hindus. Before the enactment of HMA, both parties to marriage had to be from same caste. Before HMA, both parties had to be from same caste as well. But now we do not follow it. You can marry intercaste as well. Even you can marry interreligion. You can marry a non-Hindu, no issues. But then your marriage will happen in the Special Marriage Act. Some other act will be applicable upon you. We are talking about Hindu Marriage Act. If you want your marriage to be governed by Hindu, you both have to be Hindu. Or if one is non-Hindu, then he or she can convert to Hinduism and then can marry. Then Hindu Marriage Act will be applicable. Living spouse. HMA recognizes only monogamous marriages. Marriage means single marriage. Single marriage. It should be, I should say, no living spouse. It says either party should not be having a living spouse, husband or wife at the time of marriage. Once you are married, if your marriage is subsisting, you cannot have a second marriage. No second marriage. Okay, no second marriage. Either you are a bachelor, widow, divorcee. Only these three people can marry under Hindu law. Okay, otherwise not. Free consent. Okay, marriage has to take place free consent. You cannot forcefully marry someone, or you cannot do what used to be happen traditionally. If we see some traditional Purans, if you are going to abduct a girl successfully, she will be your wife. Okay, now this is not happening here. Okay, now marriages are happening through free consent. Either parties shall be capable of giving valid consent. Okay, both the parties shall be capable of giving valid consent. And when we talk about valid consent, then we have discussed this point so many times. Valid consent means person shall not be of unsound mind. Okay, person shall not be mental. Mental and unsound mind both are similar. Person should not be suffering from epilepsy. Epilepsy is also a kind of mental condition in which you are unsound mind. So person should not be this. He should not be, you can say he should not be of unsound mind. Okay. But these categories are mentioned in the Hindu Marriage Act. Mental separately, epilepsy is also mentioned separately, and sound mind. Okay, so you should not be any of these people. Age. The male shall be minimum 20 years of age and female minimum 18 years of age at the time of marriage. Okay, at the time of marriage, male shall be 20 years of age and a female shall be 18 years of age. Otherwise, they cannot marry. Prohibited relationship. Okay, the partners shall not fall under degrees of prohibited relationship except when such union is allowed by the custom. Okay, parties should not fall within their prohibited relationship. Okay, you should not be a part of a relationship which is prohibited to get married to each other, like brother sister. Okay, you should not be in such prohibited relationship. Anyhow, we'll discuss this point in some more brief manner later on, some more detailed manner. Sorry. Sapinda. Pinda means particle in the body. Pinda is particle in the body. 5 from male side. three ancestors from female side are prohibited to marry each other. Sapinda marriages are prohibited except when such union is allowed by the custom. So we are giving a lot of scope, okay, to the custom and usage as well. You are not allowed to do these prohibited relationship of marriages, but if your custom allow it, then you can do. But only if your custom allow. It is not that you want to marry in these prohibited relationships or Sapinda relationship and you want to marry and you can marry. No, if your custom allows, then you can marry. Just because you want to marry, you cannot marry. Okay, you are not allowed. Tradition. Marriage shall be solemnized according to the customary tradition and rituals. Whatever are the customary tradition and rituals of the particular community or caste they follow, okay, those customs have to be followed and they can be married only upon those customs. So we have a ceremony. In Bengal, we have different kind of ceremony for marriage. Delhi, we have different. Tamil Nadu, we have different kind of marriage. In Delhi, marriages are taking place in the night, but in southern India, marriages take place early in the morning, 5 or 6 or 7. Okay, so marriage should take place as per the tradition of the parties. Okay, Section 8 of HMA makes registration of marriage recommended but not compulsory. Registration of marriages, it is recommended that you should get it registered, but it is not compulsory. So, now what are prohibited relationships? Okay, there's not much time left. We will discuss this in the next class then. Okay, well, next class we'll begin with prohibited relationship and Sapinda relationship. And this class time is over for it.